So Unit 2.1 really gets us into the beginnings of, what is real estate itself. We started, I know, this morning with, the rule for obtaining a real estate license. That's the licensing part of the class. The other part of the class is what actually is real estate. What is this thing that we are getting a license to help people buy or sell or lease or, those kinds of things. And so this is really that sort of first introduction into what exactly qualifies as real estate. What are we going to consider to be real estate? Now, in the class, vocabulary is huge. And most of the vocabulary that we cover is going to be vocabulary you're not familiar with. And so there'll be quite a bit of a learning curve when it comes to the vocabulary part of things. That being said, don't get overwhelmed by it. Flashcards can be really helpful. You have some that are online already in Learn, Test, Pass that you can use that are digital flashcards. You can make yourself traditional flashcards with index cards if you want to. There's all kinds of ways. But one of the things that is really helpful, I think, with the vocabulary in this class, rather than trying to separately memorize everything, is to understand that we use the same words repetitively a lot, and we just put a different suffix on the end of those words, OR or EE, based on who we're talking about in the transaction.
Is that you?
That is Bosco. I'm going to have to.
Oh.
That's a squeaker toy. Sorry. I'm giving this thing guy over here as much as I possibly can right now, so he'll stop. But
I do too. When I'm reading emails, I'm like,
I may have to put him in the hall, close the door. But this, you will see OR and EE on the end of words quite often in this class. And honestly, it does not change the meaning of the words. It just changes the person that we're talking about. Every real estate transaction, whether we're talking about a sale or a lease or a loan involving real estate, you've got somebody who kind of starts the process, the giver in the process, and then you've got the receiver in that process. There's two people. So if Seth and I were engaging in a sale, as an example, and I was selling property to Seth, I would be known as the grantor and he would be known as the grantee. It just describes two people on opposite sides of the same deal. An offer, you have an offeror and an offeree. A lease, you have a lessor and a lessee. The lease is the thing that's between the two of them. The OR tells you, are we talking about the person who started this cycle, or are we talking about the person at the end of the cycle? So whenever you see those suffixes, which is just on the end of the word, the OR person is the person that's giving that thing up. The grantor is the one who's giving up ownership. The grantee is the one who's receiving ownership. The lessor is the one who's giving up a lease. The lessee is the one who's receiving the lease. So we're going to see those a lot over and over and over. So like lessor, lessee is a really good example of that. The word is lease. That's the thing we're talking about. The question is, who's the lessor and who's the lessee? Now, the OR person is always the one who's giving. So who do you think the landlord is? Are they the one giving the lease, or are they the one receiving the lease? Which one do you think the landlord is?
Giving.
So are they going to be the OR person, or are they going to be the EE person?
OR.
They're going to be the OR. So the landlord would be the lessor, and the tenant would be called the what?
The lessee.
Lessee.
The lessee. Does everybody see how that works?
Mm-hmm. Yes.
Right? So if you're talking about something like an offer, as an example, the person making the offer would be called the offer what?
Offeree.
Or.
The one making the offer, giving up the offer, and the person who's receiving the offer would be called the what?
Offeree.
The offeree. So if we talk about this word grant right here, grant is ownership. So if we talk about somebody who's giving up ownership of the property, a transfer of ownership, you think the seller would be the grantor or the grantee? You think the seller is the one giving up ownership, or is the seller the one receiving ownership? Which one is the seller?
Seller is the grantor.
Grantor.
Seller would be the grantor and buyer would be the
Grantee.
Grantee.
grantee. Does everybody understand how those are going to work? How those suffixes just change the person we're talking about on one side or the other of that legal agreement? Because I wanted to I like to get that out of the way first, because we do see lots of repetitive use of that from the very beginning of the class. And so I want to make sure you're not trying to remember. I don't think you need to memorize two separate words. You don't need to memorize the grantor is the one giving up ownership. The grantee is the one receiving ownership. You just need to memorize that grant means ownership.
And also, I know you probably know that I was probably going to say this, but the only one that's a little bit weird is that one with the star beside it, which we'll cover later in the.
We'll talk about that one later.
Yeah.
The mortgage or mortgagee does confuse.
That's the only one that's not self-explanatory.
Well, the rest of them are very self-explanatory. Yeah. And mortgage or mortgagee is really not any different. It's just the problem is you have the wrong definition of mortgage in your mind.
We got that mental block.
Right. There's a mental block there because most people would give the wrong definition of a mortgage. And one of the things
Until it's pointed out.
Until we learn the real definition. One of the things I like to point out early in the class, and Seth will probably say this way more than I will, that's the last time we're going to talk about a loan for a long time, or at least for a little while. Because in the beginning of the class, people tend to get fixated on who owes the money, who owes the mortgage, who's paying the payments. For the whole first half of the class, folks, we're going to treat these transactions as if there is no loan involved, that these buyers have paid cash for these properties. Because what you need to understand right away is that ownership and financing are two entirely different things.
Absolutely. This would be like a parent giving their kid a car, maybe?
Oh yeah, for sure. I mean,
just to relate it to something.
If I give my kid a car, my kid owns the car. Whether I have a payment on it or not is beside the point. It's their car. The car is in their name. Same thing happens with real estate. Real estate, the ownership, the title is transferred to the owner. They might have mortgage, have a loan, or they might not. But that's really beside the point when it comes to ownership. So we're just going to eliminate this whole idea. And I want you to try to resist the temptation to tie those things together, because so much of what we're going to start to talk about, the first thing somebody asks is, well, who's making the payments? We don't care. That's the simple answer, folks, because when we're talking about the early part of the class, we're talking about ownership, and ownership doesn't have anything to do with financing. Okay?
Right.
So there are really two different types of property. Property just means something we own, something we possess, something that belongs to us. And there are two types of property that we deal with in this class. One we really care about a lot, and one we don't care about so much, but we just have to talk about it anyway, because if nothing else, we have to differentiate it from real property. Real property is the one that we really care about in this class.
Yeah.
Real property or real estate, because they mean the same thing. Real property means the same thing as real estate. If you look at this definition, it's a pretty straightforward definition if you just apply the definition. It says real property is first and foremost what? What's the most important four-letter word in the entire class? What is it that we're actually helping people buy and sell?
Land.
Without land, there is no real estate. There is no real property without land. First and foremost, whenever we write a contract for real estate, we're writing a contract for land. We don't lease somebody a house. See, that's one of the things we get caught up in our brain. We don't lease somebody a house. What are we actually leasing to them in most cases?
The land.
The land.
And a house just happens to be on it.
It just so happens that there happens to be a structure attached to it. Because look at the rest of that definition. If you look at the rest of that definition right there, it says and everything that is permanently attached to the land. So real estate is the land plus the things that are permanently attached to the land. That's why when we lease a piece of land, the home happens to go with it. Or if we lease a shopping center, we're not really leasing a shopping center, we're leasing the land. The shopping center happens to be attached to it. When we sell a property, we're not selling houses. What we're selling is land that happens to have structures attached to it. And that's a big thing to get your mind wrapped around, because ultimately without land, there is no point in this class. There's no point in the license. There's no point in any of this, because ultimately all of these deals are about the land. Now, that's real property. The opposite of real property is personal property. If you look around you right now, there are lots of things in your immediate vision that are personal property. And there are lots of things in your immediate vision that are real property. This. Real property or personal property? What do you think?
Personal.
Personal.
Personal property. The door that enters into this room, real property or personal property?
Real.
Real. Because at some point that door is attached to this house, and the house is attached to the what?
The land.
To the land.
Yeah.
So if you said, or if you were asked for the one characteristic, the one most important thing that you could look at if you were trying to determine, because I think sometimes we lose sight of the big things when we get into the details. What's the number one characteristic you're looking for if you're trying to decide if something is real property or personal property?
Is it movable? Is it attached to the home?
Is it attached?
Is it attached? Is it movable or is it attached? Personal property is movable. Your car sitting in the driveway is personal property.
Basketball goal that is buried in the ground.
The basketball goal that is buried in the ground, real property.
Real property.
Right? And so that attachment is so important, because ultimately when we sell real property or real estate, what we're selling is the land. And the land is everything that we can see, the surface, plus, and this is an important part of that definition too. Land actually includes everything above the surface and everything below the surface. So when you purchase land, you have purchased the airspace above the surface, and you've purchased what's below ground. So just kind of apply that idea. If someone were to go out, let's see who I get to pick on now. Let's say that Jennifer goes out and she buys a piece of land in Johnston County, North Carolina. And 6 months after she buys the piece of land, she finds gold buried in the dirt. Who does the gold belong to?
Belongs to her.
It belongs to Jennifer, because she is the owner not only of the surface, but everything above it. And in this case, everything what?
Below it.
Below it as well. Now, here's what's going to be interesting. You don't mind applying it that way. Now let's apply it the other way. Learning experience. Jennifer buys a piece of land in Johnston County. 6 months later, she finds hazardous waste buried below the ground. It's going to cost $15 million to clean up. Who owns the cleanup bill?
She does.
She does.
She does.
Even if she didn't cause it.
Even if she didn't cause it, even if she didn't put the stuff there, she owns the surface, she owns everything above the surface, and she owns everything below the surface. Do you think she might better look to make sure there's nothing hazardous buried below the ground before she buys that property?
Yes.
Yeah.
So that definition of land is a very important one. Now, real
It
estate
is. And something that I really just kind of wanted to throw in there is that the house is part of the land. Just to reiterate, we're not selling houses, we're selling land that has a house attached to it. So the house is the land.
That's exactly
go.
right. And that's where you get into this real estate, because real estate really is just the land plus all those things that are attached to it. Whether those things be natural, like for example, those trees there, I didn't mean to use a highlighter, that doesn't work very well. Let me change to a pen. That tree right there, is that attached to the land?
Yes,
So,
Yes.
so is that tree part of the real estate? In other words, if I buy that piece of land, have I bought the tree?
yes.
Yes.
Yes,
This structure, is it attached to the land?
I don't see a structure. Oh, okay, never mind.
You don't see the structure?
I see it now.
Oh, oh, wait a minute.
Oh.
Hang on, my connection reset there. That was weird. Let me fix that.
Yeah, just kidding.
There we
But
go.
don't automatically blanket statement assume that everything that grows in the ground is permanent. So
Well, we're gonna talk, and we're gonna talk.
we
about-
are.
But the most obvious thing here is when something is permanently attached to the land, it is part of the land. It becomes part of the real estate. And so we can have natural attachments, we can have man-made attachments, but they all ultimately become part of the real estate. And that's why I just say, don't make this harder than it is. These terms are all interchangeable. They all mean the same thing. So basically, don't overcomplicate things. If you look at something and it is attached to the land, is it real property or is it personal property? What do y'all think?
Real property.
That is the real property.
It's real property. If it is movable, if it can be picked up and moved around, is it most likely real property or personal property?
Personal.
Personal.
Personal property. Now, we may put some little, narrower definitions on that, but though that basic sort of thing will carry you a long way. Just, is it attached? That's the number one question. Now, real estate itself can be used for a number of purposes. Not all real estate is the same. And one of the things that's really interesting about getting a real estate license in North Carolina is we don't have separate licensure for the type of real estate you'd like to work in, the type of real estate you'd like to practice. There is no such thing as a residential real estate license in North Carolina. There's no such thing as a commercial real estate license in North Carolina. There's no such thing as a property management real estate license in North Carolina. It's one license that does everything. So no matter what type of property you want to work with, this is the license you need in order to help people with that property and be paid for it. And there really are three types of breaking down real estate, three overall categories. And believe it or not, commercial is not one of them.
Right.
We don't really use commercial, even though we use that word in the wild a lot. When it comes to types of real estate, commercial is not really so much a thing. Now, residential is a thing. But
because commercial could fall under any of those two that I just kind of pointed at right there. So we have to be more specific.
That's exactly right. And what it really gets to is, what are we doing with the property? Commercial doesn't really tell us what we're doing with the property. These categories are all about what is the property being used for. Look at the definition of residential. Does it say a house? Does it say that to be residential property, it has to be a house? When you look at that definition that's on the screen right there, does it say that?
It does not.
No.
No, doesn't
No.
say anything about that. So could a condo be residential?
yes.
Yes.
Yes. Could a townhouse be residential?
Yes.
Yes.
Yes. It doesn't say anything about the type of structure, because that is not what makes a piece of real estate residential. What makes a piece of real estate residential is that the owner is living in the property. They have bought this property, they own it for the purposes of living there. That is the purpose of that real estate as far as that owner is concerned. Now, here's where you have to apply what I just said. Are all houses residential?
No.
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 No, because not every house is owned because the owner of that house wants to do what with them?
Live in it.
To live there.
To live there. Look at the next category. It says income producing property is any real estate that the owner of the land generates rental income from the property. Could a house therefore not be residential but be income producing property? Could we?
Yeah.
Yes,
Yes.
absolutely. No question. If the owner generates income from the property, it is an income producing property. So that could be farmland, that could be a shopping center, that could be timberland if they lease out and make money off of selling the timber from the property. That could certainly be a home if they rent it out. That could be an apartment complex. That could be a restaurant. It could be any property that the owner generates income by leasing the property out is an income producing property. And then we have that special use one down at the bottom. And special use is really just this. It's any property that doesn't fit into the other criteria. If the owner doesn't live there and the owner isn't generating money from the property, it's a special use property. So y'all do this. Help me out here. You can throw it in the chat or you can answer out loud however you want to. Talk to me about a special use property. If you think of a property, think of a piece of real estate that you know, that you see, that the owner of that property neither lives there nor generates money from it. What kinds of properties come to mind?
Open land?
A library.
Seasonal.
Library, fire station. I love those.
What about open land?
I
So,
got church.
Open land, most likely is going to be income producing property. Very few people have land that they just don't do anything with. And that's possible, but most likely people lease out land. But when you're talking about special use properties, you're mostly talking about public use properties. You're talking about
You can say jail?
Like the park?
jail, sure, for sure.
Not retail though. That would be more like your income.
Right, and so retail would definitely be an income producing property because whoever owns that property owns it strictly for the purposes of generating income. Churches, houses of worship would probably fall under special use. Schools, yes, jails. Jails and churches go together.
Most jails are for profit.
Well, that is true. Some incarceration facilities are owned as profit producing because they're not actually owned by the state. In that case, it would be income producing. Same could be said for like hospitals. Some of them are publicly owned.
In churches.
Could be said for churches. Yes, absolutely. Event venues. So think about it. Somebody asked about event venues. Think about an event venue. What are they most likely doing with that? Do they let you use it?
Rent it out.
They rent it out. They rent it out. So which would that fall under?
Income producing.
Income producing.
Income producing property. How about farmland?
Income producing.
Income producing. Yeah, right. So the vast majority of real estate is either going to be residential or income producing. And then the ones that just don't fit into those categories fall into that special use. Now, when we talk about ownership of real estate,
Okay, listen closely, please.
we are really talking about a bundle of rights. We are talking about a group of rights that relate to that piece of land. And when we pass ownership of a piece of land from one owner to the next, we are really passing a lot of different separate things about that land, things that have to do with that land to the next owner. So like, look at some of these, like for example, the right of control. It says the right of control is the right to determine the use of the land. So when we transfer ownership of the land, does it make sense that we are transferring control of the land from one owner to the next? Does that make sense for everybody?
Yes.
And then you look at like something like the right of possession, the right to occupy the property. We transfer that from owner to owner. or the right of exclusion, which is the right to keep other people out of the property. If I don't have the right of exclusion, I can't say no trespassing. Because isn't that what the no trespassing sign really is? The right to tell other people. If you came home to your house and somebody who you did not know was on your property, what would you tell them to do?
Get the,
Get out. This is mine. That's the right of exclusion. The right to allow people onto the property is the right of possession. And then, of course, you get into like rights like enjoyment. Look at this one down here at the bottom. This one's probably the most important right of all. What do you think the right of disposition means? What is that one going to mean that is so important to an owner of the property? If they have the right to dispose of it, they have the right to do what with it that's very important to owners.
crumble it up, throw it away.
The right of ownership.
They transfer ownership, sell it,
Yes.
gift it.
Which it always leaves my mind what that means. So I just kind of connected that the root of disposition is dispose. So you have the right to get rid of it.
To get rid of it, to throw it away. And whether that's throwing it away for free or throwing it away for money, that's your choice. You're the owner. You have that right to dispose of the property. Here's what I do want you to understand about these rights, though. I'm going to back up for a second. You don't have to necessarily transfer ownership to transfer these rights. Could I just throw this hypothetically out there for you? Could I transfer, is it possible, do you think, to transfer the right of possession to somebody who doesn't own the property? Can I, as the owner, take the right to be in this property and transfer that to somebody else without actually transferring ownership to that person?
Yes.
Yes.
What do we call that?
Rental.
Lease.
That's
Rent.
that's a really long description of a lease, right? That's exactly what we're doing when we're renting something. We're transferring that right to possess the property from the owner over to a tenant. As a matter of fact, all of these rights can be transferred away from the owner except one. Which one of these rights, if you look at this list, which one do you think only the owner can have? Which one do we know that the only person
Sell
who
or
has the
dispose of
right
it.
to do this is the owner?
Disposition.
Disposition.
Disposition. Because the only one who can sell it is the one who what?
Who owns
Owns it.
Owns it. That's exactly right. The right of disposition is the only one that must stay with the owner at all times. Now, how do we transfer the entire bundle of rights? When we want to transfer the entire bundle of rights, that means transferring ownership. When we want, because remember, the one right that we can't transfer without transferring ownership is the right of disposition. So when we want to transfer all of them, when we want to tie them all together and transfer them all at one time, we need one 4-letter word.
Deed.
A very important word. We need a deed. A deed is the legal document that we use to bundle up all of these rights in that one property and transfer them. There are other legal documents that can transfer these rights, but only a deed can transfer all of them at one time. Does everybody see the difference there?
Okay.
So let me ask you a question. Would a lease transfer some of these rights?
Yes.
Yes.
Yes, but a lease would not transfer all of these rights. Does everybody see the difference there?
Yes.
So if you want a legal document that's going to take all of these rights, every single right that relates to that property, and ties it together and says, here is the whole enchilada, here's all of it, here's every right associated with that property, what legal document do we need to accomplish that?
Deed.
Need a deed.
That is called a deed, okay? And on a deed, you're going to have two parties, two participants. That's all parties mean. Every legal document has two parties. And earlier, we learned, or at least I hope we did, that one of those parties is going to have what two letters at the end of them?
OR and E.
OR and EE.
And the other one's going to have what at the end of their name?
EE.
EE. Now, when we transfer ownership, the word is grant. We are granting ownership. So we have a grantor and we have a grantee. Which one do you think owns the property before the deed is signed? Which one? owns the
Grantor.
property? The grantor. Which one is going to be the owner of the property after the deed is signed? The grantee. So let me ask that question another way. Who is actually giving up ownership here? Who is letting go of ownership of the property?
The grantor.
Or
Grantor. Who is taking over ownership of the property?
Grantee.
grantee.
The grantee. So now I'm gonna give you a sneak preview here, and then I'm gonna see how well your brains are clicking. Ready? Only one of them signs the deed. Now, I'll say that again. There's two parties, but only one of them is gonna sign the deed. Now I want you to work your way through this mentally.
This is a test question.
Right. The deed is the document that gives up ownership and transfers it over to a new person.
Grantor.
If only one of
Grantor.
them is signing, would it be the grantor or would it be the grantee?
Grantor.
Grantor.
It would be the grantor. Because because here's what we need the grantor to do, folks. We need them to give up ownership. That's what's happening. The grantor, when they sign a deed, is saying, I don't own this anymore. Does that make sense for everybody? They're literally saying to the world on this legal document, this piece of real estate that up to this point might have belonged to me is not mine anymore. And I am granting whatever ownership I have over to this person that I have named as the what?
Grantee.
Grantee.
That's a really good point, Travis, because you are going to see both of them on the deed printed, but you're only going to see one of those parties' signatures, and that party's signature is going to be the grantor only. That's going to be a test question, I guarantee you.
Absolutely.
Can
Absolutely.
you repeat that?
Nope. Charge $10 for repeating in this class.
I know that's right. No, it's also in the chat, but he'll probably repeat it as well.
No, Aloysia, it is that the grantor is going to be the only one who signs a deed. There are two parties. They're both going to be named on the deed. It's important that we name both of them, but only one of them is actually doing anything on the deed, and that's the grantor. The grantor is giving up their ownership.
So the grantee literally doesn't have to sign anything to accept ownership.
That is correct. All the grantees got to do is stand there with their hand out and say, give it to me. Give it to me.
Thanks.
Here. That's what the grantee's doing. The grantee is waiting for the, so listen, here's a whole nother test question that might come from that, and it comes from much later in the class, but you can answer it now. Legally, whose responsibility is it to prepare a deed and bring it to the closing? Who do you think?
Grantor.
The grantor. Now, let's take that word and apply it to words that are more useful for us in the real world. If the grantor is going to be the one responsible for bringing the deed, because the grantor is going to be the one giving up ownership, the grantor is going to be the one who has to sign the deed. Who's the grantor? Is that the seller or is that the buyer?
The seller.
The seller.
That's the seller. So now, test question. Whose responsibility is it to prepare, pay for, and bring a deed to closing? Seller or buyer?
The seller.
Seller.
Seller. There you go. It's their job. That's what they promised to do when they promised to sell the property. They promised to bring this document called a what?
Deed.
A deed, which says they are giving up their ownership to this new owner called the grantee. Does that make sense for everybody?
Yes.
Okay. That's what a deed does. Now, a lot of people in this class get really confused between the different legal documents that we talk about, okay? Contract is a very important word. Not every legal document is a contract, though. A deed is not a contract. A deed is something that happens because you had a contract before then. A contract is a promise to do something in the future. You sign a contract because you promise that you will do something at a later date. So a sales contract, when a buyer and a seller sign a sales contract, is the house being sold right then? Is the property sold the minute they sign the sales contract?
No.
No, they are promising that at some point in the future, they will transfer ownership between each other. Does that make sense for everybody?
Yes.
So the contract is the document that promises you will sign another document in the future. Doesn't which one comes first, contract or deed, when you're talking about a transaction?
Contract.
Contract, because you would want these two parties to sign a contract making promises to each other, and the final part of that process would be the what?
The deed.
The
deed.
The deed
So
is going to be the completion of those promises.
something else, Travis, that I think commonly gets misconstrued in class is what title is. And title would be the legal bundle of rights.
Right. Title is just a fancy way of referring to ownership. Title and ownership are the same thing. Now,
So the legal bundle of rights, whoever holds them, whoever has ownership of them has title.
that's exactly
Deeds
right.
transfer title.
Deeds transfer title, deeds transfer ownership.
You got to know that progression.
Right, deeds transfer that bundle of rights. It's all the same thing, right? So when you
Yes.
look at, so I'm going to back up, this bundle of rights, this is title.
Yes.
This bundle of rights, this is ownership. They are all the same thing.
Deed is not title.
No, a deed is not title. A deed is the thing that transfers title. A deed is the document that says title has moved from one person to another person, from a grantor to a grantee. And listen, we're going to repeat this about 40 million times because it does take a while for these legal ideas to start to sink in to your brain. Now, that bundle of legal rights, remember, as a group, they represent ownership. So let's just quickly talk about what each one of them represents. We said the most important one is this right of disposition. The right of disposition is the right to sell the property. And we said only which party has the right to dispose of the property. Which one has the right of disposition at any time with any property? Always.
Grantor.
The grantor.
Grantor, owner.
Owner, the current owner of the property. That's the only person who could possibly have the right of disposition, the current owner of the property. Whereas when you compare that like to the right of enjoyment, it says the right of enjoyment, I can use it without interference from others who would also claim the right of enjoyment. Could we transfer the right to enjoy the property over to a tenant? Is that possible?
Yes.
Yes.
Yeah. As a matter of fact, we generally do. Generally, when we lease property, one of the rights that we transfer over to the tenant is the right to use and enjoy the property during the term of that lease. Now, when I say transfer it, do I mean we've transferred that right forever to that tenant, or have we transferred it for just a limited amount of time?
Limited amount.
Limited.
A limited amount of time, right? We could also transfer this
For a contract.
of exclusion. I have the right to tell people, so like right here, my house, 114 Heidinger Drive in Cary. I have the right to tell people to get the hell out if I want to, because it's mine. I have that right as the owner.
You could give it to a tenant.
But let me ask you a question, Seth. Do you have the right to tell people where you live right now in your space right now to get the hell out? If one of these people just popped in, like stalked you and popped in, could you tell them legally to get out?
Yes, and I rent.
But you're not the owner, right?
Right.
So what we're saying is, even though he's not the owner of that property, he still has the right to exclude people from that property, because as a tenant, we have transferred that right to him. The owner has transferred the right of exclusion. Now, here's what's interesting. Does the owner have control over who's in that property right now, or does Seth, the tenant, have control over who's in that property right now?
The tenant.
Seth, the tenant does. And that's one of the things that people don't understand about leasing, folks. When you lease, if you transfer a right over to the tenant, you don't have it yourself as the owner. For whatever period of time you've given them that right, you've given that right to the tenant, not to the owner. Here's why that's important. Look at this next one. Let's talk about this one for a second. The right of possession. The right of possession is the opposite of the right of exclusion. It's the right to occupy the property. Now, I picked on Seth for a second. Who else rents? Anybody else rent? Like, show of hands, rent where you live? I saw Jordana. Is it Jordana or Jordana? Jordana? I didn't.
Jordana's good.
Jordana?
Yeah.
I think she said Donna.
She did say Donna?
No, Jordana's right.
Okay.
Perfect.
All right. So you rent, right? Correct?
Yes.
You said you rented. You have the right of possession in that property. In other words, you have the right to legally be there, correct?
Yes.
Okay. So let me ask you all a question. Does Jordana's landlord have the right to come in there and crawl in bed, go to bed with her tonight?
No, he's my brother.
That would be weird. But here's why that's an important question. Because as the owner of property, are there going to be landlords who think that because they're the owner, they can do pretty much anything they want, even though they've leased a property to a tenant?
Yes.
Right,
Yes.
Yes, but they can't. What would we call it if Jordana came home and her landlord brother was sitting in her living room without her permission? Is there a name for that?
Trespassing.
Trespassing. And depending on how he got in there, potentially breaking and entering.
Mhm.
Even though he's the owner of the property, because he does not have the legal right to be in that property, because he did what with that right for a limited amount of time?
Transferred it.
Temporarily transferred that right of possession. Is that starting to click for everybody what we mean about giving up these rights for a certain period of time? See, the difference in a lease and a deed is a lease gives up some of the rights for a limited period of time. A deed gives up how many of the rights?
All
All of them. For
Everything.
how long?
forever.
Forever. Everybody see the difference now? A lease is giving up some rights for a limited period of time. A deed is giving up all rights forever in the property.
So Russell
Permanent transfer.
and Russell had asked in the chat, two people can't own the same right at the same time.
So in general, Russell, no, but they could agree to. They could agree to share. That's where a written lease outlining exactly what the rights would be very important. If they wanted to share those legal rights, they would need to be very specific in that lease. So, like as an example, what if somebody rents out their basement? Here's my question. If they don't have a very specific lease saying what portion of their property they've rented out, could the tenant make an argument that the tenant is renting the entirety of the property?
Yes.
Yes.
Sure they could. And that's where you run into problem with sharing those legal rights. You need to be very, very detailed when you start to share those transfers of rights.
And let's also just make a really quick distinction, just in regards to Moth's question. You can always create a document to do anything legally, but as far as like, you know, what's kind of tested, this is kind of like what you need to stick
exactly.
with.
And that's why written contracts are so important, because if we were going to share that right of possession, if we were going to share that right of exclusion, we need to be very clear about that. Because I will tell you this, who do you think the courts would side with? If there's no written lease if they went to court and there's no written lease and the tenant can prove that they've paid rent, do you think the court would say that the tenant probably has the right to some portion of the property or all of the property? Who do you think the courts would always side with?
The tenant.
Tenant.
Tenant, every
Okay.
time and always.
And let's just also reiterate, it all depends on what your lease says. Every lease is not the same. So, as far as Aloysia's question, it has to say in the lease if the maintenance people can come in at certain times, if they need to make an appointment 24 hours in advance, etc.
And that's a perfect example. Aloysia said, so if you're renting an apartment and a maintenance crew asks to come in or say they have a mandatory job to take care of in the apartment, legally, can you refuse? Well, the answer to that is it depends. Does your lease specify that they have that right? Now, if your lease, so let me ask y'all, this is where you got to apply. You got to think critically here. Let's say Aloysia's lease says nothing about a maintenance crew coming in to do work on the property. There is no mention whatsoever. Can she legally refuse and say, you ain't coming in here. You don't have the right to come in my property. Can she do that?
Yes.
Yes.
Yes. Because if the lease doesn't say that that right is shared, then the landlord transferred all of that right of possession and all of that right of exclusion to the tenant. Does that make sense for everybody?
Yes.
But if the written lease that both the landlord and the tenant sign says that the tenant agrees that the landlord can have a maintenance crew come in with 24 hours notice, does the tenant now have to allow the maintenance crew in with 24 hours notice?
Yes.
Okay.
Can't refuse.
Because they agreed to it. So the answer to the question there would be, it depends on if you have a written lease and then what that written lease says.
Mhm.
Okay. But by default, we assume that these rights have been transferred in their entirety. I love the way Russell just said that. He said it exactly the same moment that I said it. Was basically the entire right is transferred unless some document says otherwise. And that's exactly the way we think about it. That's exactly right. We only put limitations if we put them in writing. If we don't put in writing, there's no limitation. So we would transfer the whole right of possession and the whole right of exclusion. Is everybody with me on that?
Mhm.
Yeah.
Okay. So the right of control, what's the property is used for? That's another example of a right that could either be the landlord or the owner. But we always go back to that right of disposition. That right of disposition just really cannot be replaced because only the owner can have the right of disposition. I would flag this slide, if I were you, as something you should come back to, because this is probably the single most important vocabulary word in the entire class. I mean, it's hard to say it is the absolute most important, but I think it's certainly up there. This idea of an appurtenance. What is an appurtenance? And that's a fancy word. An appurtenance is anything that we can see, touch, feel, or anything that's legally attached
Conceptual.
to the property. It could be conceptual. It can be an idea. It could be, like, for example, if I own a property that is lakefront, do you think as the owner of lakefront property, I probably have the right to access the lake from my property? What do y'all think?
Yes.
Yes.
Yes. Now let me ask you a follow-up question. If I sell the property to William, do I still have the right to access the lake from that property, or does William now have the right to access the lake from that property?
William.
William does. So here's the truth. Did that right to access the lake ever actually belong to me, or did it belong to the piece of land that I happen to own?
To the land, to the property.
It belonged to the land. Here's how we say that legally. The right to access that water is appurtenant to the land. In other words, the right is going to stay with the land. It's going to transfer with the land. If you want the benefit of being able to access the lake from a piece of land, you better do what?
Buy the land.
You better buy that piece of lakefront property. Otherwise, your butt is not going on the lake.
So what about a house though too? Like a house is appurtenant.
That's the other thing. Appurtenances can be physical things that we can see and touch, like structures are also appurtenances. The expression I always use with appurtenance is, and I listen, I get it. It was my grandfather's favorite expression and I love it. And you may have heard it, you may not, but I say it all the time. The fleas come with the dog, folks. In other words, the good comes with the bad. They are tied together. You do not get to pick and choose one or the other. If you buy a piece of real estate, anything that is appurtenant to that piece of real estate is coming with it. So let me give you an example of that. How many of you live in a neighborhood where there are restrictive covenants? Like there are covenants that say, you know, you gotta put your garbage cans away at a certain time, or you can't have them out in front of the house, or you gotta. Those of you that raised your hands, do you love the covenants, or do you think sometimes this is a bunch of baloney? This is just some, I cannot believe. Right, Somerset.
Sometimes.
I like it.
So now here's the thing.
It
Whether
can be
you like
nice, but they can be really ridiculous.
and that's why they're a great example. Some people love them. Some people hate them. Some people like some of them and hate the rest of them. It doesn't matter whether you love them or hate them. They are appurtenant to that land. Here's what that means. When you get ready to sell that property, is the next owner going to have to follow that exact same set of restrictions that you had to follow?
Yes.
Yes.
Yes, because the restrictions are not on you. The restrictions are attached to the what?
The land.
Property, the land.
To the property. That's what we mean when we say it's appurtenant to the property. It means it is bonded to the land. That means once it's there, look at that last bullet point down there. How long are most of these appurtenances? This is why it's the most important vocabulary word in the class. When we say something is appurtenant to the property, how long is it going to last?
Forever.
Forever.
I don't think that registers sometimes though. You know, there's no way to rip the appurtenance out. There's no way to do away with it. It's there forever.
There. It is stuck.
And I still don't think it registers sometimes, but
it is.
We'll come.
Can I give a few examples? I could give hundreds of examples. I can give you an unlimited number of examples, but you have to step back for a second before you're going to understand any of the examples, Trisha.
And also, I do have to call Crystal out because she did, and it might be a little early, but she did mention HOA, which is never your answer.
We're going to talk about HOA a lot and why that's not really ever the answer.
But we'll cut you some slack today.
HOA is not a thing, by the way, folks. The HOA is, when you say you can't stand them, Crystal, look in the mirror, because guess who the HOA is?
All the landowners.
It's you. The HOA literally stands for Homeowners Association. It is you. You hate yourself. It's a group of you. And that's why it's never the answer in this. We love to blame it, and it's almost never the test answer. The HOA is us. Because you're going to get test questions. Who enforces the rules? It's not the HOA. It's the property owners.
Your neighbor.
Individual property owners. So I promised I'd give Trisha some examples of appurtenances.
And I know Taj had
Can I ask a
her
question,
hand raised.
Travis?
Sure, go ahead, Elizabeth. You're muted though, Elizabeth.
You said the homeowners are not the people, are the people that enforce, not the HOA. But the HOA is made up of the homeowners. So they give those people the authority to adjudicate the CC&Rs.
Well, that's exactly what I'm saying, because people think the homeowners association is some magical mythical thing that just got brought down from like a mountain, chiseled in stone. The homeowners association is just you as a group of homeowners. And if they've decided to hire a management company as a group, they decided to hire a management company in the group. But don't walk around saying you hate your HOA. Walk around saying you hate your neighbors, because they're the ones doing it to you, folks. That's who you hate. And
When you
yourself,
get that letter,
by the way,
Or get involved and run for office and then change it.
that's right. That's it. And that's what, now, appurtenances. So let's talk about appurtenances. Let's say, as an example, there is a covenant in a neighborhood, a rule, a restriction in a neighborhood that says every house has to be at least 2,000 square feet. That's a very common sort of restriction you might see in a subdivision, minimum square footages. Now, that restriction was placed on the property at some point in the past by a previous owner of the property. Now, before we overcomplicate things, I want y'all to think about this. Would it be hard to get 100 people who own houses in a neighborhood to all agree to place the same rule on their property at the same time, to place the same, because the only person who can place a restriction on the property is the person who owns the property right then. Would it be hard to get 100 people to be 100% in agreement and say, we're going to place this rule against our property all at one time? Would it be hard to get 100 different
Yes.
people to agree?
yes.
Yes.
Very hard.
Yes. Let me ask y'all a question though. If you back up far enough in time, is there ever a point that you get back to where one person owned all 100 lots at the same time?
Yep.
Yes.
How about the developer, the builder? At some point, didn't the builder developer own all 100 of those lots at the same time?
Mm-hmm.
Yes.
Yes.
Is it pretty easy to get the owners of all 100 lots to agree on a rule or a restriction when one person or one company owns all 100 lots at the same time?
Absolutely.
Yes.
So when do you think these restrictions get put in place, folks? It's not a rule that they have to, but when are these restrictions put on the properties most of the time?
And they're built.
When they're developed. It's the developer that usually places these restrictions all at once, right? So let's say that restriction was put there 30 years ago. Houses have to be at least 2,000 square feet. 50 years forward into the future, you're selling a lot in that neighborhood. Is that restriction still going to be attached to that property? What do y'all think?
Yes.
Yes.
Yeah,
It is, because it's appurtenant.
an appurtenance, yeah.
It's an appurtenance. So
Down
an
here in
appurtenance-
Southern Pines, we have a Young's Road, which is has a ton of gentleman farms on it. And they have a restriction that no lots can be smaller than 10 acres.
There you go, right? You may have minimum lot size restrictions, all kinds of restrictions that can be placed. Now, keep in mind, here's what I want you to understand. These were placed, people say, how can they do that? How can they put restrictions on my property? They didn't put restrictions on your property, honey bunches. They put restrictions on their own property. They restricted property that was theirs. But what they said was, everybody who buys this property in the future is going to have to follow this restriction. That's an appurtenance. There we go. Look at Tyler's question. There's a great way of thinking about it. Tyler said, so can I buy a piece of land and put appurtenances on that land for any person I decide, he said lease, but I'm going to say sell to in the future? Can I put appurtenances on land I own? What do y'all think?
Yes.
Yes.
Yes. So let's say I decide that I like my house being yellow. It's mine. I own it. Can I go down to the Wake County Courthouse and place a written restriction against 114 Heidinger Drive in Cary that says the structure on the property must always be yellow? Can I do that?
Yes.
I can, because it's my property. I'm only restricting myself. Does that make sense for everybody?
Mm-hmm.
And people say, but that's not fair. You're restricting those people in the future. Here's why it's so fair. That person that buys it from me, guess what they have to be aware of when they buy it?
The appurtenance.
Oh, that covenant.
Appurtenances. They have to be aware that they are taking over ownership subject to all these restrictions that have been placed against the property. Does that make sense for everybody?
Yes.
What about something that was illegal, that was legal before, that's illegal now?
So that's a great question. And that does happen with appurtenances. The appurtenances themselves will stay there forever. They don't disappear, but they become unenforceable. So, you know, unfortunately, there are some fairly common examples of William's question with discriminatory type covenants. You know, as an example, developers routinely in North Carolina in the 1940s, 1950s, 1960s would build neighborhoods and restrict the sale of lots to persons of certain races, or restrict the sale away from persons of certain races. And they made them part of the covenants. Unfortunately, the nature of covenants is that they're appurtenant, and so therefore they stay attached to the property. But to answer your question more specifically, William, they are unenforceable. Covenants that, first of all, you can't place any covenants on a property that are illegal at the time you place them. But if the law changes at some point down the road, covenants that are in conflict with
And illegal
are not enforceable any longer. So it's one of those. It's one of the more unfortunate aspects of real estate is that you'll see covenants that are gross, disgusting, and you just have to acknowledge and say the covenant's there, but it's not enforceable any longer.
Are those on the deed?
They are not always on the deed. We're going to talk about that. They could be located on the deed, but when you say the deed, that's really a misnomer in and of itself. Every property has dozens of deeds, hundreds of deeds, because every time we transfer ownership, there's a new deed. So when you say, is it on the deed, which one? Eventually, at some point, it was on a deed for the property. That doesn't mean it's on the most current one, but they're still enforceable if they were ever on any deed for that property.
I know that in California, when I read the deed, it said that if any part of this document is deemed illegal, that part is automatically stricken. So that took care of not having to get it off there.
That's right. And unfortunately, we don't have such a law that automatically strickens them here. We just say they're unenforceable. So some examples of appurtenances that we can see and touch: buildings. Buildings that are attached to the land are appurtenant, meaning they transfer with the land itself. They are part of the land. The right to access water that's bordered by the land is appurtenant. The right to access gas or minerals or timber is appurtenant to the land. Leases are appurtenant. Here's what that means. If I sell a property and it's currently leased, the lease stays with the property. So now apply that to the real world. If a lease is appurtenant, let's say, so I'm gonna use, I'll pick on a couple of you here again. Let's say that Charmaine owns a property and she has it leased for the next 6 months. And she's selling that property to Wendy. Is Wendy going to have to honor that lease for the next 6 months to Charmaine's current tenant? Even though Wendy never negotiated it, never dealt with it, even though Wendy may not want the tenant there, is Wendy going to have to honor that lease?
Yes.
Yes, because the lease doesn't actually belong to Charmaine. It belongs to the land.
to the land.
Property.
It stays with the property, right? And that's what I mean when I say the fleas come with the dog, folks. These things are part of the land. They're part of the property, and we cannot separate them from the property. They go with the property. So kind of moving forward in that progression is this question of, is something real property or is it personal property? Because when we start to look at real estate transactions, it's really important for us to know the difference between real property and personal property. We need to know when something is going to be considered real property or when it is considered personal property. Now, if you look here on the slide, it says that if it's personal property, it is not going to be included in real estate transactions. Unless, what's the unless part? Talk to me here. Unless what?
Unless you put it in the contract.
Unless you otherwise stated in the contract. But then what does it also say about real property? It says real property is included in the transaction unless what?
Otherwise stated in the contract.
Unless otherwise stated in the contract. So here's the thing you got to make sure of. Don't get yourself locked too far into a corner and ignore what they're telling you about a contract. If we're trying to determine if something is going to be included or not in a transaction, your first question should be, well, what does the contract say about that thing? Does the contract say it's included or does the contract say it's not included? We only go to this definitional sort of difference if the contract doesn't specify, if the contract doesn't tell us whether it's real property or personal property. Now, we already talked about personal property is pretty much anything that's movable. And we talked about real property is pretty much anything that's attached. The word fixture is the word that we use to describe things that have been permanently attached and have become real property. Fixtures are real property. And there are several different types of fixtures, which we're going to talk about. Some people get really in their head about this phrase permanently attached. So I've tried to give you my definition of what permanently attached really means. You can forget the permanent part. If the thing we're talking about is nailed or screwed or glued or buried in the ground, it is attached. So I'm going to say that again. If we're trying to decide if something is a fixture or not, we want to know, is it attached? By attached, we mean, is the thing nailed to the property? Is the thing screwed to the property? Is the thing glued to the property? Or is the thing buried in the ground? That's the first question we're going to have to ask ourselves, because things that are fixtures are part of the deal. If it's a fixture, it's part of the transaction. It's automatically included. If it's personal property, it's not. Let me give you a practical question example about that. If I write a contract, so I just wrote a contract on a house this weekend. We talked about it earlier. There are clothes in the closet. Are they part of the deal or not? Now, I'm just going to tell you, there's no mention of the clothes at all in the purchase agreement. Are they part of the deal or not?
No.
No, because they are what kind of property?
Personal.
No.
Personal property. Okay. The ceiling fans are not mentioned in the contract at all. Are they part of the deal or not part of the deal?
They're real property.
They are part of the deal because they are what?
Attached.
They are real property. Does that make sense for everybody?
Yes.
Okay. Now watch this. Watch. Listen. The refrigerator. The refrigerator.
Personal
property.
Y'all think that would be personal property or real property?
Personal.
Personal.
Personal. So is it part of the deal?
Not
No.
unless
No, not unless what?
it's
It's
in
in
the
the contract.
Not unless it's mentioned in the contract, right? Well, guess what? It's mentioned in the contract.
And appliances.
So if it's mentioned in the contract, are we going to make it part of the deal?
Yes.
Yes.
Yes. Let me ask you this question. The boat lift, which is attached to the boathouse and the roof of the boathouse, real property or personal property? What do y'all think?
Real.
Real property. So is it part of the deal?
Yes.
Yes.
What if the contract specifically mentioned the boat lift? Would it be specifically mentioning it to say this is part of the deal, or would it be specifically mentioning it to say this is not going to be part of the deal?
It's not.
This is not.
It's not. Here's the connection you need to make. You only bring up something in the contract if you want it to do the opposite of what it would do if you didn't mention it. Does that make sense for everybody the way I just said it?
It does.
Yeah.
So I only need to mention the refrigerator if I want to make it part of the deal, because normally a refrigerator is what?
Is
No.
not
It's
mentioned
not part
or
of
part of it.
Personal property.
I only need to mention the ceiling fans if I want them to be what?
Removed.
Excluded.
Not part
part
of the deal, because normally ceiling fans would be part of the deal. Does everybody see what I mean by that?
Mhm.
Yes.
Because that's the way they're going to give it to you on the test. What they're going to tell you is, here's this thing, and it was specifically mentioned in the contract. Well, you're going to have to recognize, well, they only bothered to specifically mention the thing because they wanted it to do the opposite of what it would normally do if you just left it out.
So what if it mentions like, appliances included? Is refrigerator part of appliances, or is it appliances and refrigerator?
Would you tell me why you're asking that question?
Because I heard someone say appliances.
Mhm.
I'm
And you
like,
thought that word was vague?
mhm.
So if you thought that word was vague, what do you think about somebody who includes a word like appliances in a sales contract?
Not
They
sure.
could just
I
mean
would say
a
I would say
microwave.
such a person
Right,
probably
that's what, when I think of
probably
what I
needs to
think
be
stove.
with a brick, right? Because you can't do that in a contract, because that's exactly why you can't do it. Appliances, what does that mean? I
But
mean,
I've seen it in so many contracts.
because they're idiots, because they're idiots. So
You can't just say refrigerator because it could be a broken
a
refrigerator.
dorm refrigerator, a broken one. You better
Very
put a serial
specific.
number. You better be specific if you're gonna get that. That's what contracts are all about. Very
Mhm.
clear. Needs to be very clear.
I have a question for what about like mobile homes or like stuff like that? What would you do?
We're gonna talk about those, but Russell, you actually answered your own question with the first word you just used.
Mobile?
Mobile. What kind of property do you think a mobile home is?
Move it.
Personal property, baby.
Like,
There it is.
like those trailer homes and stuff, like they lift them up and like they take them on the E-way. Like I was behind one the other day, like
That's personal property. That's it. Yep. So always check the contract before you answer questions, right? Always check the contract. See if the contract is specific about that thing you're talking about. If the contract doesn't specify, right? If the contract doesn't specify whether this thing is going to be part of the deal or not, then and only then will you apply the following test. Okay. So people ask me, this question will come up a lot. They'll say, the blinds, are they real property or personal property? What do you think my first answer is going to be? Read the slide. What do I tell them to do first? When they ask me if the blinds are personal property or real property, what do I tell them to do first?
Check the contract.
Read the contract.
Contract. See what your contract says. See what the promise was. Does the contract that was signed between these two people say how you're going to handle the blinds? Because the next page, I cannot stress this enough, the next page is only going to matter if the contract says what about the blinds?
That there will be.
That they're excluded.
About nothing at all. Because if
Oh.
the contract says anything about the blinds, do what the contract says. If the contract says do this with the refrigerator, then do that with the refrigerator. Don't worry about whether it's a real property or personal property. That's where people go wrong. People want to apply the fixture test first. That's not the way it works. What do you look at first when you're deciding if something is included or not?
Contract.
The contract. The contract is more important. I don't care. Is a rug a fixture? What do y'all think?
No.
No.
No, but if the contract says the rugs are going to be included as fixtures, am I going to bother to try to figure out if the rug is a fixture? Or am I just going to say, well, the contract says it's a fixture, so it's a fixture,
Contract.
right? So whenever you, and I'm telling you on the test, that's what's going to happen on the test. when they start asking you, is something a fixture or personal property, what's the first thing you're gonna look for in the test question? Did they tell you what?
If it was mentioned in the contract.
Is it mentioned in the contract? How does the contract say you're supposed to be handling it? You only go to this next test if the contract doesn't say anything at all. People ask me this all the time. Well, what about the flat panel TV on the wall? Is that a fixture? Is it personal property? Where's the first place to go look?
Contract.
The contract. If the contract says the TVs are included, then guess what?
They're included.
They're included. If the contract says the TVs are not included, then guess what?
They're not included.
They're not included. If the contract doesn't say anything about the TVs, then we got to go to the next slide. Does that make sense for everybody?
Yes.
You only apply this test if the contract says nothing about that thing we're looking at. And this is the fixture test. If the contract does not specify that the thing you're talking about is going to be considered a fixture or not, then you will apply this test, but always check the contract first. And this is a 2-question test, and it's set up like a flow chart. Follow the answers, and it will tell you whether or not you're going to consider this thing a fixture.
Follow the yellow brick road.
What is it? What does it say question number 1 is for this thing?
Is the item permanently attached?
Is the item permanently attached? And we said permanently attached meant nailed,
glued,
or buried in the ground,
or
right?
buried.
Nailed.
Say that 5 times fast.
Nailed, screwed, glued, or buried in the ground.
Travis, what do you classify as like TV mounts on the wall? Because when I moved, I had to leave all the TV mounts.
So here's the thing. Don't talk about what happened when you did what, because remember, the people you're dealing with are morons, most likely, and don't know the law, right? So let's apply the test here. You're talking about a TV mount. First of all, first question I have to ask, the contract you used, did it specify whether the TV mounts were going to be considered a fixture or not, or was the contract silent about that?
It was silent.
The contract was silent. So if the contract didn't say anything at all about the TV mounts, now we apply the test. Everybody with me so far on Mandy's question?
Yes.
Okay. So contract silent. So let's apply the test. Question 1, is the TV mount permanently attached? Is it nailed or screwed or glued or buried? Is it one of those, Mandy?
Yes.
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 Now follow the arrows. Yes does not mean it's a fixture. Yes takes us to question number what?
2.
2.
Okay. We're still not a fixture. We got to go to question number 2. Now, if the answer had been no, would we be done? If the answer was no, it's not permanently attached, what would the thing be?
Personal property.
It'd be personal property, not a fixture. Okay. But because her answer is yes, then we go to question number 2. Question number 2. Was the TV mount attached by the owner of the land, the owner of the real estate? In other words, who put it up, Mandy? Who installed the TV mounts?
I did. I didn't personally, but I did.
You had it done on your behalf, right?
Yeah.
Right? Okay.
Yeah.
So is that a yes then? It was installed by the owner of the land? So question number 1, is the TV mount permanently attached? Yes. Question number 2, is the TV mount installed by, was it installed, was it attached by the owner of the land? Yes. What is the TV mount?
A fixture.
Fixture.
It is a fixture, and therefore it should have stayed attached to the property and should have stayed part of the transaction.
Okay, so let's flip it. She rented the house out to me, and I put the mount up.
The TV mount. So let's walk our way through that. Seth rents where he lives. He may have his TV
From
mounted.
Mandy.
From Mandy. He may have his TV mounted on the wall. Same exact TV mount. Y'all following me on this? Follow the questions. Is the TV mount permanently attached? That's a yes. So we go to question number 2. Was the TV mount attached by the owner of the land? And Seth said he put it up and he is a tenant. So what's the answer?
Oh,
No, and if the answer to that question is no, what is that TV mount in that case?
mine.
Property.
It is personal property. It is not a fixture. So another way of saying that is if the thing that we're asking about was installed by a tenant, it is not a what?
Fixture.
Not a fixture.
Gotcha.
So if you were buying a property that was leased, do you think it would be really important to ask if anything that was here was installed by the tenant? Because you'd know they would have the right to remove their stuff.
Absolutely.
Yeah.
Mhm.
Mhm. How do we feel about that little flow chart? Everybody okay with that?
Yeah.
Feeling
Feeling
good.
like a break, to be honest, but
Like 40 minutes ago.
Can I just recap this so I
hey,
got it
30
straight in
minutes
my
long
head?
time.
First thing you do is check the contract and see if the item is mentioned there.
That's right.
If it's not, then you go to these two questions
That
and
is
you
correct.
do what they say.
That's
Okay.
right.
That's
Exactly right. This is your fail safe if the contract does not specify. That's exactly right. Exactly right. So I'll give you a perfect example of that. The most commonly used sales contract in North Carolina specifies that an electric range is going to be considered a fixture. Now, let me ask y'all a question. If you applied this test, would an electric range be a fixture or not a fixture?
Not a
not a fixture.
Not a fixture because it's not permanently attached, right? An electric range just pulls out from the wall. It's not attached. It plugs in.
That's
it's
true.
not, right? But if the
I guess it depends, but
But if
typically.
the contract says the thing's going to be considered a fixture, do we ever even get to the point of applying these questions?
No.
No, you.
That's why
only-
you look at the contract
That's
first.
why you always look at the contract first.
Because as a buyer, you would specify in the contract that the stove is to stay,
There you
correct?
go. That's right. To be safe. We only get to this if we leave it up in the air. That's exactly right. Okay. This is to settle the disputes. That's what this is for. This is you didn't agree in the contract what was going to happen with that thing. So we're going to figure out which one should it be. Should it be a fixture or should it be personal property? Okay.
So Travis, as an agent, it's incumbent on you then to counsel your client, your buyers as to what things we want to or don't want to put into the contract?
Yes, for sure. Absolutely, for sure. All right, so why don't we do this? Let's take like a quick restroom break, come back at 2:30, and then we'll have a short remainder after that. But come back at 2:30 and we're going to talk about some rights that are associated with property ownership other than the fixtures. And but we're also, before that, we're going to talk about a little bit more of a differentiation between what things are personal property and real property, specifically in real estate transactions. Okay. Yeah, I know.
Can you move your picture up higher because it's covering some of the text on the slides?
Can I hold my picture?
Move your little picture there that's in the corner of my screen. Can you move that up higher on your screen?
You can move it on your screen.
I can. Okay, good. Thanks.
Yeah, you have control of that. So you can minimize me or move me around. So, all
Okay,
right.
so you said 2:30?
Yep, come back at 2:30.
Okay.
Take a quick break. So this terminology improvement is really a simple one. An improvement is anything that we have built or constructed on the property. It can be an actual structure, but it could just be sidewalks. It could be drainage systems put on the property. It could be the installation of a well. It could be the installation of a septic system. Improvements are an example of an appurtenance because they are attached to the property as well. One of the most common questions, and Russell asked it earlier, that we run into in real estate transactions, especially in North Carolina, is whether a home which is not a site-built home is going to be considered real property or personal property. And there are two types of homes that we encounter. They're called modular homes and or manufactured homes. And they are two very different things in North Carolina. Manufactured homes, which are the more prevalent of the two, which often are referred to as trailers or trailer houses or single wides or double wides. There's a lot of different terminologies people might want to use, but manufactured homes is the correct terminology for it, are considered to be personal property. The word mobile tells you the story. They are constructed and intended to be mobile. They are on a chassis, just like a car. They have wheels, just like a car. They are intended to be moved at some point, which means they're going to be considered personal property. Now, that does not mean they cannot be converted into real property. So we're going to talk about that here in just a second. They can be converted into personal property, but here's what you need to understand. When you see one of these, your basic assumption should be it is or is not part of the land. Which one?
It's not.
Is not.
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 Automatic assumption, but doesn't always mean that.
No, you have to verify, but your basic assumption to be safe is that this is not part of the land.
Right. And this is also something that won't be highly tested, but you will see at least one question on it. And people do get these mixed up quite a bit. So I would go ahead and find a way to associate manufactured with mobile and then not associate that with modular.
Modular homes are, for all intents and purposes, homes. They are no different than site-built homes, but mobile homes,
manufactured and mobile, it's hard. It's easy to get mixed up.
Manufactured mobile homes are very different. They are personal property. They can eventually be converted to real property. They are personal property until all of these things, 1, 2, 3, have happened. Not one of them. So somebody asked a question there. Tosh asked, what about a mobile home that's been bricked? That's not enough. All 3 things have to happen if you're going to convert this thing into real property. It has to be put on a permanent foundation. There's the bricking part. But you also have to remove the wheels, the axles. You cannot leave anything under there. The wheels and axles have to come out. The towing hitch has to come off the front. I know some of you all from where I am in Eastern North Carolina have seen that triangular shaped flower planter on the front. That is not going to fly. It's got to go. It cannot still be there for it to be converted into real property. And then you have to go to the Department of Motor Vehicles and turn the title in because it is no longer a vehicle. Up to that point, it was a vehicle. It has a vehicle identification number, just like a car does. And it is personal property until all 3 of those things have been done. That is not the test question you're going to miss. This is the test question you're going to miss about these things. And I cannot hammer this home enough about the test, but also for the real world. Some of you are not going to like this when I say it. I'm sorry, but I have to say it because you have to understand it for your real estate clients. This is not meant to be an aspersion on this type of structure. These are, by law in North Carolina, unsafe for human occupancy. By law in North Carolina, every manufactured mobile home is unsafe for human occupancy. I'm going to say it one more time so you understand it. By law in the state of North Carolina, a manufactured home is what?
Not safe.
Unsafe.
For law.
Unsafe. North Carolina law.
And here's why I say that. Because they are exempt from the building codes. What is the purpose of your building codes? To maintain what?
Minimum safety standards.
Safety.
And these are exempt from the building codes. They do not comply with the building codes.
This will be your test question.
This will be the test question. These are not built to meet the standards of your local or state building codes, and they never will. They cannot be retrofitted to meet the building codes. They cannot, converting them into real property does not make them meet the building codes. They will always and forevermore be considered by law in the state of North Carolina unsafe. Now, that does not mean you shouldn't live in them. Doesn't mean you should It just means you have to understand as a
There's a
real,
lot more that goes into these.
this is the legal treatment of them in the state of North Carolina.
A quick question. Once you make them real property, how can they get a CO?
They can't. They don't. They don't.
Okay.
And a CO would be like a
They will never
certificate
have
of
a
occupancy.
They will never have a certificate of occupancy.
If they don't ever have a certificate of occupancy, how can you get a loan on them?
In many cases, you cannot. It is very tough to obtain financing for them for that very reason.
Good question.
Yeah. They are completely outside of the building process in the state of North Carolina. Now, that's not going to be the same for every state. Different states have different treatment of them. But in our state, North Carolina takes a very harsh treatment of manufactured homes. And there's just no way to bring them into compliance with the building codes. That is not it is not well received sometimes from people. People want to be stubborn and say, first of all, let me give you an example of this. Red flag you need to look for as a real estate agent. How many of you have seen a porch built onto a trailer, an addition built onto a trailer? How many of you have ever seen that?
Yes.
Every single one of them is illegal. Because not only does the trailer, the manufactured home, not meet the local building codes, you can't get a building permit to make an addition to one of them. So that means that that porch or that addition was built without a what?
Or building permit.
With no permit.
And we have to seriously make a connection here. Like for Summer's question, it says, how do mobile home parks exist? Because they either own or lease that land, but they've already bought that trailer that they're putting on there. Right. It's personal property. So it exists because they're leasing the land.
You just have to understand, how do we buy any piece of personal property with loans? We get loans on cars. Those are personal property. There are lenders who will lend on these, but they are different loans than you would get for a site-built home, because this is not a home in the state of North Carolina. It just is not. It's a vehicle. And even when it's been permanently attached, it's a vehicle that's been permanently attached. It's not the same thing. And that's the test question. And people miss it out of stubbornness. That's why I'm so forceful with it. It's not, listen, 2/3 of my family still lives in manufactured housing. I grew up in that manufactured housing. I got no bias about it, but you need to understand what it is, because when you got buyers looking at it, this is the state that treats it very dimly. And so you need to understand that. It is just not going to comply with local building codes. That's the best way to understand it. And that's the big differentiation that you're going to get with modular homes. Modular homes do comply with local building codes. They are built to meet your local building codes. In other words, if you are purchasing a modular home, the modular home company has to get in touch with your local planning and zoning office, get a building permit, and build the house, even though it's being built in a factory in pieces, to meet your local building codes. And then when it's assembled on site, the building inspector comes out and inspects it the same as they would with a site-built house. So modular houses are homes and do meet the building codes. Is everybody clear on the different treatment here legally between the two in North Carolina?
Yes.
Okay, that's definitely where the test question is probably going to come from with them. Okay, trade fixtures really are just another type of fixture that is installed by a tenant. You just need to know that vocabulary. A trade fixture is a fixture that's been installed by a tenant, in this case, a commercial tenant. And anytime, as we talked about earlier, that something is attached by a tenant, the tenant can always remove that thing as long as they do so before their lease expires. They can, the tenant always, so when we talk about a trade fixture, as an example, let's talk about, let's say I rent a building and I put an automobile repair shop in there, and I have to install lifts for the vehicles. Well, those lifts are going to be bolted into the floor, probably bolted to the ceiling of the building as well. Just because they're attached does not mean they cannot be removed, because they were installed by a tenant. The fact that it was a tenant that installed them means they can be removed as long as the tenant does so before their lease expires and puts the property back in its original condition. Then they are the personal property of the tenant who installed them. Plants. Most plants that are planted in the ground are going to be considered real property. If it's planted in the ground, it's buried. The vast majority, so what's the number one thing you're going to look for with a plant? If you're trying to decide if a plant is real property or personal property, you're looking to see, is it buried in the ground or is it in a pot? If it's in a pot, is it real property or personal property?
Personal.
Personal property. If it's buried in the ground, it's most likely what?
Real.
Property.
Real property. And that is true across the board, except one type of plant. There's one type of plant that could be planted in the ground that's going to be
Marijuana.
considered personal property. Well, marijuana might be an example of that, depending on, because marijuana is a plant, to the best of my understanding, that has to be cultivated on an annual basis. It is a crop. It does not grow back year after year. Crops are plants that do not come back year after year. So like, for example, your tomato plants, you plant them, they grow, they produce one time, that's it. Once they freeze, there is no more growing back. Corn, soybeans, peanuts, cotton, tobacco, all of those are crops. They have to be replanted every year. They do not come back year after year. So think about when you're selling a home. The vast majority of the plants do not have to be replanted year after year. The vast majority of them would be like shrubs or the actual grass itself or trees. Those would all be considered real property. When do you think this becomes important? Not when we're selling houses. What kind of land would we be selling where this distinction would become important? That the crops in the ground are personal property.
Farmland.
Farmland. If we're selling farmland, we need to be really careful to make sure we understand that the crops that are currently in the ground are not going to become the property of the new owner. Who's going to own the crops even after the property is sold? If the crop, assuming the crops are still in the ground on the day of closing, who's going to own the crops even after the property is sold?
The grantor.
Whoever planted
The seller.
the seller, whoever planted them. What about if a tenant farmer is leasing the land and plants the crops and their lease expires? Who do the crops belong to?
The tenant.
The tenant, right? And here's what North Carolina says about that. If crops are in the ground, you have to leave them there until they're ready to be harvested, which means you also have to let that person who planted them come back onto the property in order to harvest them. So just as a practical matter, if you were going to sell a farm, when should you probably schedule closing?
After harvest.
After harvest.
After harvest. If you were leasing a farm, when should you schedule the lease to expire?
After harvest.
After the harvest, right? That's really the only thing you need to know. Otherwise, with plants, if they're buried in the ground and they come back year after year, it's real property. If they're buried in a pot or planted in a pot, then they're personal property. If they are a crop, they are personal property of whoever planted them. That's how we handle plants. Okay. When we have property that borders water, and this is really the last topic we want to talk about today. When we have property that borders on water, whether that be the ocean or a lake or a pond or a river or a stream, we have a duty to understand two things about this water that our property borders. Number one, do we have any ownership at all of the water because we own the land next to the water? That's the first thing we need to know is, do we have any ownership of the water itself just because our property is next to the water? That's the first question.
No.
And the second question is going to be, do we have rights of access to the water just because our property borders on the water. And I will tell you, the answer to these is going to be, it depends. And here's what it depends on: the type of water that you are a neighbor of.
And just to throw, go ahead.
What I was going to say is, if you are a neighbor of a big piece of water, you don't own the water. The water belongs to the public. If you are a neighbor to a small piece of water, you probably own some of the water.
And just to throw something in there, Riparian is going to be broken down into two parts. So when we progress through these, don't get confused. The way I'm sending it in the chat is how they're going to be broken down. I might have needed to know that when I was learning this.
Well, that's because the littoral bodies of water are so big, there is no such thing as a non-navigable. Littoral bodies of water are the ocean. The ocean is.
Yes, but as we progress through these slides, I would have been like, wait, hold up. Where are we starting? Where are we ending?
So honestly, people make this far more complex than it is. A body of water is water you can see. We're not talking about a well. We're talking about water you can see on the surface. We're talking about rivers, lakes, streams, ponds, oceans, those kinds of things. So water you can see, right? If it's a big body of water, the landowner is not going to own the water. Big bodies of water belong to the public. If it's a tiny body of water, a creek, a pond, then the landowner is probably going to have some ownership of the water itself because it's too small for the public to care about it. That's really all we're trying to differentiate here. Now, we get fancy words to differentiate those. We talk about riparian bodies of water and littoral bodies of water. A riparian body of water, this is a definitional thing. A riparian body of water is a body of water that does not have a tide. Does a river have a tide? First of all, do we know what a tide is? Let's talk about that, because you're not going to understand that definition. And I know some of you are like, oh my God, of course I know what a tide is. But some of you don't know. A tide is when the water, not a wave, that's not a tide. A tide is when the level of the water changes regularly at certain times of the day. The water level is at a different place at certain times of the day than it is at other times of the day. The water is higher at certain times of the day than it is at other times of the day. And it is a very regular repeating pattern. Certain times of the day, the water's higher. Certain times of the day, the water's lower. Where do we see that? We don't see that in rivers, lakes, streams, creeks. They may rise, but they rise when it rains or they rise when it dries out. What body of water changes based on the time of day, every single day, multiple times a day? That's the ocean. That's the ocean. The ocean is the only body of water that we need to worry about in North Carolina that has a tide. Now, if you were in Michigan, I would tell you the Great Lakes you need to worry about because they're big enough, they have a tide. But in North Carolina, the only body of water that we have that has a tide is the Atlantic Ocean and the Albemarle Pamlico Sound, the sounds and the ocean, right? Riparian bodies of water are all the bodies of water that don't have a tide. So basically anything other than the ocean is going to be called riparian. Is everybody good with that definition? Anything other than the ocean is going to be called riparian. The problem with riparian bodies of water is some of them are huge, like Lake Gaston, 172 miles of shoreline. That's big riparian body of water. It's still riparian, it doesn't have a tide. Jordan Lake, that's a big riparian body of water. But how about a pond in the middle of an HOA or in the middle of a neighborhood? Is that also a riparian body of water? What do y'all think?
Yes.
But yes. It's really what?
Yes.
Really small, right? So riparian bodies of water cover so many different types of body that we need to break them down into two categories. Riparian, and this is what Seth was mentioning earlier, gets broken down into two subcategories. Little bodies of water and big bodies of water. All water that doesn't have a tide. Okay, we're not talking about the ocean, we're talking about anything other than the ocean. So some riparian bodies of water are small, not navigable. Okay, the sound would be littoral, Dawn. The sound, Albemarle, Pamlico Sound, as well as the Atlantic Ocean would be littoral. They have a tide. Okay, so non-navigable riparian bodies of water. What do you think we mean by non-navigable? Small. Give me examples of bodies of water that do not have a tide. That
Like
would
a
be-
creek.
A creek. What else?
A creek you couldn't get like a
River.
kayak on.
A creek. How about a pond? Yeah.
Pond.
Creek, pond, stream. Those kinds. Of things. Lake, I would not put in that category. Lake, I would put in what category here?
Navigable.
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 Navigable. A lake would be an example of a navigable riparian. They're both riparian because neither one of them has a tide, but the lake is navigable. You could easily take a boat out in it. A river, do you think that would be non-navigable or navigable?
Navigable.
Navigable, right? But creeks and streams and ponds would be non-navigable. So look at these two pictures side by side here. These are both riparian bodies of water in North Carolina. Now, first of all, let's talk about what does the riparian part mean? Help me out. What does riparian mean?
Doesn't have a
Does
tide.
not have a
Neither
tide.
one of these has a tide. So they're both riparian bodies of water. But these are the two categories of riparian bodies of water based on size. The one on the left, tiny. It's a non-navigable. It's 4 or 5 feet wide and maybe a foot deep. It's a non-navigable riparian body of water. So here's the issue we have here. We have lot number 1 over here and lot number 2 over here. Everybody with me so far?
Mhm.
Here's the problem. I need to know where the boundary is between lot number 1 and lot number 2. We need to know where this property line is. And then when you look over on the right-hand side, I've got lot number 1 over here and lot number 2 over here. And I have the same problem. I need to know where the boundary, where the lot line is. And I will tell you the answer is going to be different in these two pictures. It's going to be a different answer in these two pictures. Here's what the difference is. Who do you think this water on the right-hand side in the navigable one, who do you think the water belongs to? Do you think the water belongs to the landowners, or do you think the water belongs to the public?
Public.
The water here belongs to the public. All of this is public property. So then let me ask you a question. Doesn't that immediately give us the answer to where the property line is for lot number 1 and lot number 2 on the right-hand side?
Right at the edge.
It's going to be right there on the shoreline, right?
Mhm.
Isn't that going to be the property line?
Yes.
Yes.
Pretty much if it's wet, it belongs to the public. If it's dry, it's private property. Does that make sense for everybody?
Right.
Yep.
But the one on the left is a little bit harder to deal with. The one on the left, the water is too small for the public to care about it. Because how's the public going to access that water? It's not navigable. You can't get there with a boat because a boat won't what?
Fit.
It won't fit. It won't float. You can't get there with a boat. So since the body of water is too small for a boat, the water does not belong to the public. What we are going to do with this body of water is split it right down the middle. In other words, this side of the water belongs to property number 2, and this side of the water belongs to property number 1. That is the difference between a non-navigable body of water and a navigable body of water. Does that make sense for everybody?
Yes.
When you have a
Yes.
navigable body of water, the water itself is going to belong to the public. And therefore, so now let's answer some questions that naturally flow from this. Who can use the water on the navigable side? On the right-hand side, who can use that water?
Anyone.
Anyone. On the left-hand side, who can use the water?
The property owners.
Only the people who own properties 1 and 2. Does that make sense for everybody?
Yes.
Okay, that's the difference here. Now, somebody asked a question, how can we put a dock in a public waterway? Well, generally speaking, you have to get permission from the owner of the property. Who owns that property?
Public.
The state.
The public does, which would be the state of North Carolina. And in general, that's exactly how you put a dock on a public waterway. You have to get permission from the state of North Carolina or from whoever they have assigned to manage that waterway. Like, for example, in the case of Lake Gaston, the state of North Carolina has given Dominion Power control over the lake because they use it for hydroelectric power. And so you would go to Dominion Power to get a permit to build a dock. And the reason you have to get a permit to build a dock is because the dock is located on public property. It's in the water, and that water belongs to the public. And so you need permission from the state to build it out there.
But Madonna said that the dock belongs to the public. Is that true?
It does, absolutely.
Because it's now appurtenant to the water, correct?
That is correct. It belongs to the public, technically speaking. That is correct.
So
Yeah.
Travis, may I interrupt you real quick? So you're saying even if a homeowner, like we have a lake house.
Yep.
Our dock needs repair.
Yep.
But it's in South Carolina, so I don't know if that is even relevant, but it needs repair. Is it on us to repair it? But we have to have special permits from.
You were in North Carolina, you'd have to go to the state or whoever the state had given control over that body of water and get a permit to make any repairs.
Gotcha.
You can't
Okay.
place a board on that thing because
Right,
it's
right,
public
right.
property.
Okay.
Yep.
But they also determine the size, if you can extend it any further, larger, wider.
Or
Okay,
put it there in the first place. That's exactly right.
all right.
Exactly right. Because it's their land. The water belongs to the public. So like we said, if the riparian body of water is not navigable, the property line is going to fall in the middle of the two lots, the middle of the body of the water. And if the riparian body of water is navigable, then the property line is going to be at the water's edge. Now, with littoral bodies of water, which are the ones that do have a tide, we don't have to worry about the non-navigable part. These bodies of water are huge. They're all navigable. The problem we have with this body of water is that we can't just say the water's edge. What's the problem with saying the water's edge in this picture? What does the water do?
It moves.
It moves, and it moves with a tide. Now, we're not just talking about the waves themselves. We're talking about the tide. Right now, if you were to come back 6 hours after this picture was taken, would you see a lot more water in this picture?
Yes.
Yes.
The tide line. So how do we determine where the property line is going to be with a littoral body of water? It is going to be the high tide line.
High line.
The high tide line is going to be considered the property line for littoral property owners. That means if you own one of these beachfront houses, you own up to the high tide line. Anything past the high tide line on the beach is all public property. That's all public property out there, which means anybody can be on that property.
Mm-hmm.
That's how we handle water access rights in North Carolina. How we all feel about that?
Great.
Pretty good. Yep.
Good, good. Just quick mention here, and then that'll wrap us up on this section 2.1. Subsurface rights. The word subsurface just means below the surface. And so when we talk about subsurface rights, we're talking about the rights to things below the surface. Water, for example, being able to put a well in to extract water from the ground. That's a subsurface right. Gas rights, oil rights would all be subsurface rights. It could be anything that comes up from the ground would be referred to as subsurface rights. And these rights can be leased. to companies. They can be sold to companies. As an example, you could sell the rights to the gas. You could keep ownership of the land, but sell the rights to the oil and gas that's under the land. That can all be done separately. This is just vocabulary I would suggest you take a look at in case you see it on the exam. Don't invest a lot of energy in it, but just some vocabulary terms that you might see as far as water goes. Accretion is building up of land because the water has deposited more soil. That would give you more property. Obviously, the more dirt you have, the more land you have, the more property, the further your property line is out. Reliction is gaining land because of drought, basically. If the water line, so you look at like Lake Mead in Nevada, Arizona, in that part of the country, Lake Mead is continually receding. Lake Travis in Texas is continually receding. And so if you own properties that are on those lakes and the water keeps getting further and further in, well, if your property line is the shoreline, aren't you gaining more land as the water retreats?
Yes.
That is a process called reliction. Erosion, most of us are familiar with if you're from North Carolina, because we've heard that terminology a lot. Erosion is the loss of land because of water. As the water beats against the land, it takes away the soil. That's the process of erosion. And avulsion is basically like a mudslide or a collapse due to water. All of those are just, I don't think you'll see test questions about them necessarily, but you would maybe see them mentioned in tests, and I just want you to be familiar with the terminology if you see it. So here's an example of, some rights that and how it might be presented. It says Tom owns a farm in Nash County and sells the timber cutting rights to International Paper. 30 years later, Tom's children have inherited the farm property and they sell it to Carla. Who currently has the right to cut timber from the farm? So what do y'all think? If Tom owned a farm and sold the timber cutting rights to International Paper 30 years ago, and then his children eventually inherit the farm and sell it to Carla, who owns the right to the trees there now?
International Paper.
International Paper.
National paper.
That's
I
exactly
would say
right.
Dunder Mifflin, but
Yeah, it could be Dunder Mifflin.
me.
Most likely International Paper. But yes, once those rights are sold off like that, it stays that way. That's a really important thing to understand when you start looking at, especially farmland or land that's undeveloped. Have the timber rights been sold at some point in the past? Air rights, the right to develop things above the surface, is also an example of an appurtenance. And then the last couple of pieces of terminology that we mentioned in this section, again, just for vocabulary purposes, we owe our neighbors support rights. We cannot create situations on our own property that would cause our neighbor's property to collapse. We cannot excavate or dig right up to the property line, which would cause a collapse of our neighbor's property. It's just not realistic. We owe our neighbors those support rights. And that